Greetings everyone. Welcome to Narayana IAS. This is Manda Chaitanya. Today I am going to do detailed daily news analysis of the articles from the Hindu as well as the Indian Express. The articles that we are going to discuss today are as follows. Firstly, the right to reproductive choice of women, which is from the Hindu. Next is about the electoral bond scheme, where the Supreme Court has taken up the case on the constitutionality. The third one is of the India's vision that it wants to attain until the year 2047. The fourth one is recently 2 cities have entered into UNESCO Creative Cities Network. Coming to the first article, it is on reproductive choice of women. We are going to see the Supreme Court judgment which has given its view on the Medical Termination of Pregnancy Act, to what extent it is applicable on the women. The topic of relevance in UPSC. In UPSC, it is with respect to Reproductive Rights of Women, Medical Termination of Pregnancy Amendment Act 2021. So these are what you're going to learn today. The subject is mentioned in the UPSC syllabus. It is related to GS1 Indian Society and GS2 Social Justice. In Indian society, you will learn about the women here, to what extent the rights of the women are being exercised and how they are curtailed by the state or the judiciary, and the social justice. Here we are going to see the justice with regards to the women's rights as well as the unborn child. The title is Impacting a Woman's Freedom to Reproductive Choice. As I already explained you, it is with respect to reproductive choice of the woman. Now, firstly, let us look into the judgment given by the Supreme Court. On 9th October, a 2-judge bench of the Supreme Court has actually favored women by granting her the right to terminate the pregnancy. And the thing of it is, the woman's right has been granted despite it not being the grounds under which termination of the pregnancy is possible. That is Medical Termination of Pregnancy Amendment Act 2021. Under this act, termination is allowed only on 2 grounds. We are going to see these 2 grounds in the next slide. Okay. Woman has argued her case through her lawyer that she is facing postpartum depression, and also her lawyer argued that her socioeconomic conditions doesn't permit her to raise the child in a perfect way, or her socioeconomic conditions are not perfect enough for her to raise a 3rd child. That is the argument put forward by the lawyer. And the 2 judges have taken her issues into consideration and have granted her the right to terminate the pregnancy. Again, on 11th October has given a split verdict. Okay. One of the judges was in favor of granting rights to women, that is reproductive choice. The other judge has gone into the consideration of the life of fetus as well, and thus was against granting the right to the woman, right to reproductive choice. Why? Because in this case, before termination of the pregnancy, the fetus is to be killed. That is, the fetus is alive and its heart is beating. We need to stop the heart and then we need to terminate the pregnancy. So this has ultimately led to split in the verdict, because an AIIMS doctor has given a report on the viability of fetus. AIIMS doctor has said that the fetus is alive and we need to conduct feticide. Then only we could terminate the pregnancy. Then what happened is, again, on a 3-judge bench has taken up the case, which was headed by Justice Chandrachud, which has said that the present scenario or present case doesn't fall within the Medical Termination of Pregnancy Act 1971 and the amendment bill, which was again passed in the year 2021. That is, it doesn't have the grounds on which the right to freedom of choice, in this case the reproductive choice, could be exercised. We are going to see the law. You will be able to understand what we are talking about. Now let us look into Medical Termination of Pregnancy Amendment Act 2021. What does it say? It says that within the weeks of pregnancy from 0 to 20, we need to just take the advice of one doctor, and there are no conditions that are required to be met by the woman to attain or to exercise this right to reproductive choice. She could terminate her pregnancy. No conditions need to be met. It is her choice. But after 20 weeks, the conditionalities are to be met by the woman, then only she could exercise the right to reproductive choice. That is from 20 to 24 weeks. The consensus of two registered medical practitioners is required. That is, two doctors have to give their assent or consensus to the woman. Then only she could exercise the right to reproductive choice. The conditions are few, like for example, survivors of rape or victims of incest, etc. These are the conditionalities she should be able to meet to exercise this right. Again, beyond 24 weeks, only two grounds are available under which she could exercise the reproductive choice rights. These are the fetal abnormalities and the immediate threat to mother's life. Whereas in the case we are arguing, there is no immediate threat to the woman's life. Okay? She is suffering from postpartum depression. Doctors say that this doesn't immediately impact her life. That is, her life is not in danger. At the same time, the fetus is viable. It is viable. That is, the fetus is alive. So this has ultimately led to declination to the woman with regards to exercise of rights. Why? Because these conditions doesn't fall within the Medical Termination of Pregnancy Act 1971 and Amendment Act 2021. Now let us look into the judgments closely and try to understand right to reproductive choice is not absolute. We should also look into the life of the fetus, life of an unborn child, or life of the egg. So let us look into the grounds that support right to reproductive choice of women. First one, health conditions of the woman. If the health of the woman is in contention here, that is, if the health is not perfect, then the right should be extended to her. The issue here is to what extent we should consider the health of the woman. Is she suffering from ailment that might threaten her life, or certain health conditionalities which actually makes it difficult for her to actually see that the pregnancy and the aftermath of it, that is giving birth to a child, could be carried out in a healthy manner or not as per her mental conditions or her physical states, etc. Her physical state, her medical state. So the postpartum psychosis, whether this should be the ground of termination of pregnancy or not, giving right to reproductive choice to the woman, or the tablets that she consumes that ultimately leads to the possibility of complications upon the unborn child which is in her womb. So we should take this into consideration. Next is the forced pregnancy. The possibility that the pregnancy might not be planned, or the sexual interaction between the husband and wife might lead to a child which they might not have planned. And the contraceptive measures that they have taken might not have worked, that ultimately led to conceiving of child. So these conditions are also to be looked into before taking a decision on the reproductive right choice of the woman. Then is the socio-economic conditions of the family. If her socio-economic conditions doesn't enable her to actually raise a child, okay? For example, the family has already 2 children and they are trying to raise a 3rd child. But they are against it. Why? Because their socio-economic conditions doesn't permit to raise a 3rd child in an environment which is viable to the child health or child's upbringing. If their socio-economic conditions are not in such a manner, they will not plan for the 3rd child, right? But yet certain times it might happen naturally. That might impact their ability to sustain the family. Many times they do not plan the 3rd pregnancy, but somehow it happens due to one or the other conditions that we have already discussed, but that will ultimately lead to certain complications. Like in this case, for example, the woman didn't plan the pregnancy, but it has happened due to the sexual intercourse between her and her husband, and she didn't know that she is pregnant until they reached 24 weeks period of time. Next is, it also depends on the marital status of women. Okay, the marital status of women. For example, after the conceiving of the child, that is the start of a pregnancy period, their relationship might not be healthy enough for them to deliver the child as per the expectations or as per the likings of the woman who is in relationship. The Supreme Court in the year 2022 has given a judgment on the basis of the relationship status between the husband and wife. And it argued about transformative constitutionalism. It argued that the pregnancy or the reproductive choice given to the woman should also take into consideration the relationship status. Then the right needs to be extended to the woman. That is what the Justice Chandrachud, who has given the judgment, in this case has given his verdict. This is called transformative. This is called as transformative constitutionalism, which the Justice Chandrachud has put forward. He says that the law should take into consideration the changes that are happening in the society. Now we are focusing more on individual rights. So here the individual rights are given more priority, and thus the decision or thus the wishes of the woman are taken into consideration in granting the rights. Then the points against the right to reproductive choice that are to be extended to the woman. The first one, it violates the fundamental rights. Okay? Why? Because here we should also take into consideration the right of the unborn child. The right to life under Article 21 is impacted. Presently in the Constitution, we might not have any provision that extends right to the unborn child. We might not have any provision. But if you read the articles in a broad manner, we could also extend the right to the unborn child as well, because that too carries life. Next, but at the same time, we take into consideration the right of an unborn child with respect to succession and sex determination. Okay, we determine the sex of the fetus. Whereas the termination of the pregnancy is done as per the law that we have already seen. Next up is ethical consideration. That is, it is against ethics. If you look into the professional ethics of doctor, it is in favor of life. Professional ethics of doctor dictates them to see that the life flourishes rather than end here. Why? Because we are conducting abortions. Next up is whether the feticide could be allowed before termination of the pregnancy of the baby if the baby is viable. Okay, we already talked this case. If the fetus is alive, should we allow abortion or not? Why? Because we are taking away the life of the child before terminating the pregnancy. Next up is the conception of pregnancy is consensual. Is it ethical or moral? Okay, why? Because once the pregnancy is conceived and it is on account of the consensuality between the partners, then should we give them the right to reproductive choice? Okay, so these are certain ethical and moral considerations that we have to look into before granting rights to the woman. And the international perspective, Roe versus Wade judgment was in favor of the reproductive choice of women, but up until the life of the fetus. If the fetus is viable, the grant of right to reproductive choice is in contention and it can be extended. That is the judgment given by the US Supreme Court. The judgment of the court that was recently given opens up new dimension. The first one, should the right of the fetus be greater than the right of the woman over her body? That is the choice of the woman or the right of the woman. Who should be given more priority? This is one issue that it opens up. The next one is the Constitution or any legislation doesn't mention the right of the fetus or right of the unborn child, which is still in the womb of the mother. Next up is Medical Termination of Pregnancy Act 1971 or the amendment which was brought in 2021, whether all of them have the absolute supremacy over fundamental rights of the citizens, because here we are taking away the fundamental right of the woman, the right to take her own decisions over her body under Article 21, right to privacy, Puttaswamy judgment. So there are many questions that it opens up. Okay, That is individual rights, whether individual rights are supreme or we should enable the legislations to bypass these individual rights. The conclusion is we should take into consideration both the cases. We should look into the unborn child's life rights, at the same time the choices of the mother, which might be dependent upon certain complicated factors which we might not be able to comprehend, like the socio-economic conditions, their ability to raise children, etc., etc. Now I'm giving a mains question with respect to the article that we have discussed till now. The question goes like this. Medical termination of pregnancy is criticized to be in favor of the rights of the pregnant mother while ignoring the right to life of the unborn child. So we have taken both the cases and tried to expand our views on it. Now critically analyze this topic. Okay. Coming to the second article, it is about the constitutional validity of electoral bonds. So it goes by the title in the newspaper, Selective Confidentiality in Electoral Bonds May Not Suffice. So presently there is a case proceedings that are going on with regards to the constitutional validity of the electoral bonds. The relevance of the topic is electoral bonds, political funding, implication in transparency and accountability, related constitutional questions. So you will be able to answer these questions once this article has been dealt in detail. With regards to prelims in Indian polity and mains GS2 polity and governance. The importance of the topic is huge because we have already seen a question in the mains which was about the use of electronic voting machines. There was a controversy surrounding electronic voting machine. Similarly, you could expect the question on electoral bonds because it is important with respect to the elections that are conducted in India. The deepening of democracy depends upon how the elections are conducted in India. The context. A 5-judge bench of Supreme Court have been hearing a batch of petitions with regards to the constitutional validity. What is constitutional validity? Whether the provisions of the constitutions actually give scope for electoral bond scheme to operate in India. Whether electoral bond scheme which leads to funding of political parties is actually fair enough to be valid as per the constitutional provisions, constitutional spirit, because democracy is one of the important provisions of the constitution. It might not comply with the expectations or the standards set by the constitution, and Supreme Court is the one which is going to examine the constitutional validity. Next is the concepts. Firstly, what is electoral bonds? Electoral bond is an interest-free bearer instrument. As the name itself suggests, it is interest-free. Even though you might buy electoral bonds, it will not fetch any interest. Its value depends upon the value of the electoral bonds. We will see the value of the electoral bonds as we go along in this slide as well. It is a unique form of financial instrument. Okay, it is a financial instrument through which you could donate money to the political parties. You would buy the bond from the bank and you would give this bond to the political parties of your choosing. And this giving of bond is done through banking transaction, banking channel. Okay, you will buy a bond and you would donate it. And for donation, you will use the banking channels, and thus ultimately you are donating money to the political parties. Now let us look at the scheme. Only Indian citizens or body incorporated in India could buy this bond. Body incorporated, for example, the companies. Companies which are running as per the Indian statute, Indian law. And it is issued in denominations ranging from 1,000 to rupees 1 crore. So you could donate to the extent of 1 crore, starting from 1,000 rupees using this scheme. It allows anonymity. That is, you could see that through this instrument, you would not disclose your identity. You could buy the bond and you could give it to the political parties using the banking channels. It will not lead to disclosure of your identity. So you will be anonymous. Next is, it is governed under Income Tax Act 1961. And it is through State Bank of India, you will conduct the transactions. As I said already, banking channels is the medium through which you conduct transaction, and it will be possible only through selected State Bank India branches. Now, the constitutional debate, which is of importance for us. The question of selective confidentiality. There is an expression in the Supreme Court that the confidentiality is not absolute and the confidentiality is restricted. Why it is restricted? Confidentiality in the sense we are seeing that the donors are anonymous. We are not disclosing the identity. There is a reason for not disclosing the identity. So the confidentiality is selective in the sense the ruling party has the possibility to know the names of the donors. So that is the issue that has been raised. It is through investigative agencies and also through SBI. But we have already quoted that the reason for electoral bond scheme is to promote anonymity. But the ruling party is able to know the names. So that is the issue that has been raised. Next is the question of right to privacy. That is, our opinions are our own private matter. We don't want it to be disclosed to the public. Why? Because the freedom of expression is also political in nature. Our political opinions are what matters here. Why? Because if we express our opinions, there is a possibility of witch hunting. A particular political party might not like us, so it might target us. So that is why certain individuals like to see that the political opinions are private in nature rather than disclosed in the public. Okay? The problem is donors' privacy is not protected, as we have already seen. Next, the state through law enforcement and SBI could actually get and access the information of the donor list. Donor's identity is political right, as I already said. And protection of political affiliations against the state is a fundamental right. Okay? Next is the problem of anonymity. See, anonymity should not be absolute, because many times unaccounted money could also be routed through this electoral bond scheme, which ultimately is nothing but using black money to influence political parties. So in those points of time, we require disclosure of the identity. But this scheme, as it provides anonymity and also channels to maintain anonymity, is problematic. For example, it is said that the large donors wouldn't like their identity to be disclosed. They will use various small routes, like for example, many individuals, to see that their money is routed into political party funding. If that happens, we will not be able to locate the individuals who are using unaccounted money to conduct transactions. So there is a possibility of black money influencing the politics. This question has been raised in the Supreme Court. And instead of investing in big sums, what these big players do? These big players use these kinds of channels to route the unaccounted money. And the problem is the undue advantage it gives to the ruling party. The ruling party was able to see that the mobilization of political funding is mostly done to its channels. So this is problematic. Why? Because it gives an undue advantage to the ruling party in contesting elections if it has more money. If you look at the number, BJP has been able to secure close to 5,271 crores. The next is just 952 crores. It is less than 1/5 of what BJP has received. And electoral bond scheme is a major route through which the funding to political parties is happening as of now. And the possibility of retribution. The issue here is that the political parties might actually target individuals for their political opinions. Because if one knows the identity, then we'll know his political views. Especially the ruling parties are alleged to use the agencies as well as government machineries to act as a tool of retribution and target certain individuals. So under Companies Act, the thing is that we could actually know the details of the donors. Which company has donated how much amount of money to which political parties. So that is the constitutional debate that has been raised. Now let us look into the practice question. Prelims. With respect to electoral bond scheme, consider the following statements. It introduced an interest-free bearer instrument for political funding. We have already seen it is a bearer instrument and it is interest-free. Next, it is governed by the rules under the Representation of Peoples Act 1951. This statement is false. It is governed by IT Act 1961. Next, Only political parties who secured at least 10% of the votes polled in the last general elections of Lok Sabha or Legislative Assembly are eligible to receive electoral bonds. This statement is false because the condition is at least 1% of votes. So, how many of the statements are not correct? We have seen the second statement is incorrect and the third statement is incorrect. So, the answer is 2 statements. Now, let us look into the mains practice question. Analyze the challenges and potential reforms needed in the context of political financing. So, given the way electoral bond scheme is functioning in India, you could utilize the figures as well as the arguments put forward to write this answer. Coming to the third article, virtues of planning. It gives about India's socio-economic aspirations that it wants to attain until the year 2047. It gives Vision India at the rate 2047. What we want to attain until the year 2047. The relevance of this topic is GS3, Indian economy and planning. How it is important? We have seen a previous year question in the year 2015 which is about Atal Innovation Mission. So similarly, we could expect questions on the mission. That is Vision India at the rate 2047. Coming to the context, why it has come in the news. Prime Minister has recently released a document which gives us the Vision India at the rate 2047, that is it wants to attain a vision of $30 trillion by the year 2047. So that is the reason it is in news. Coming to Vision Plan 2047. It is prepared by Niti Aayog. Niti Aayog has prepared this document by collaborating it with central and state governments. In addition to it, it also went into discussions and consultations with the various stakeholders like industry, academia, civil society and the public. Now, the objectives. So, the objectives are, as we have already seen, $30 trillion and by the year 2047, and also to see that India's per capita income reaches to the level of $18,000 to $20,000. At the same time, we want to see that we will overcome this middle income trap and address regional economic disparities. We have economic inequalities in India between different regions. That is the aim of this document. Now, coming to the key points that explain the Vision India 2047. Avoiding the middle income trap, regional economic development, per capita disparities, skill development, focusing on becoming a global player, and shifting towards government as an enabler. So these are the key goals. Now, how to attain these goals? Avoiding middle income trap, we want to attain by transitioning ourselves from agriculture to industry. Because presently in agriculture, close to 45% of the population is still dependent on agriculture for their livelihood. The income generated by the agriculture is not high enough for us to transition towards high income economy. So middle income trap overcoming requires us to transition towards industry. Next, regional economic development. We want to see that all the regions in India are developed. Because in India, certain regions are developed more when compared to others. For example, Maharashtra. Whereas certain states are lagging behind, like Bihar. So we want to see that all the regions are able to participate in the economic development of the country. At the same time, the inequalities between them is addressed. And per capita disparities. We have per capita income disparities among the Indians. Certain are high income individuals, certain individuals' income levels are poor, that is below poverty line as well. We want to see that the income levels of all the individuals are increased. And skill development, we want to see that the population is skilled enough to make us a transition, a leap forward, because we could use their demographic potential to make India a high income country. World Economic Forum's Global Competitiveness Report 2022 has already shown that Indian skills are lagging. That is, the skill levels of Indian population is not high enough for us to compete at the global level. We are positioned at 48th out of 141. We have to become top 10. That is how we would be able to realize the potential of Indian country. Focusing on becoming a global player. We want to see that our industries compete at the global level, produce manufacturing goods that will be having high demand in the global economy. Next, shifting towards government as an enabler. We want government to be as an enabler to see that we could participate freely in the economy so that we could realize our potential. So the regulations should not be constraining enough. Government should come forward and make us provide and make us an environment where we could realize the potential. Coming to the conclusion, the 2047 plan and aim for 9% growth between 2030 to 2047. All these will ultimately enable us to realize the vision. Practice questions. Mains question. Elucidate the key pillars of the Vision India 2047 document and discuss their implications for India's economic and social development. As we already seen about this document and how it tries to see that our potential is realized through planning, regional economic disparities overcoming, etc., you could tackle this answer through the points that have been already mentioned. Prelims practice question. With reference to Vision India at the rate 2047, consider the following statement. It is prepared by Ministry of Statistics and Program Implementation. As we already seen, it is not prepared by Ministry of Statistics, it is prepared by Niti Aayog. So the first statement is wrong. Next is, it aims to make Indian economy a $25 trillion economy by 2047. The actual aim is $30 trillion economy by the year 2047. So both the statements are false. Now, which of the above statement is or correct? Neither one nor two. This completes this article. Coming to the fourth article, 2 of the Indian cities have entered into UNESCO Creative Cities Network list, which is released by UNESCO. This article is of importance both from the prelims perspective and mains perspective. And from the mains perspective, the questions could be asked on the Indian heritage and culture. At the same time, it could be quoted as an example for the sustainable development of cities. Now let us look into the cities that have entered into this list. The 2 cities are Kozhikode in Kerala and Gwalior in Madhya Pradesh. Kozhikode has been listed into this UNESCO site list under literature, okay, for its literature importance. Next, Gwalior of Madhya Pradesh for its music. Okay. Now, let us see the number of cities that have been presently represented in this list. The total are 55 cities. So 55 cities are placed into the list. Out of it, recently 2 Indian cities have been entered into this list. Now let us look into UNESCO Creative Cities Network 2024. What is it? Now let us look into UNESCO Creative Cities Network, which has started in the year 2004. It is to promote cooperation with and among cities, to promote sustainable urban development. So it is all about using creativity and utilizing the energies of this creativity to promote sustainable urban development. So placing creativity and cultural industries at the heart of their developmental plans. See, each city is unique in its own perspective. Like we have seen, the Kozhikode is famous for its literature. We utilize these creative potentialities and use them for planning purpose and promote urban development. The network covers 7 creative fields. Like we have already seen, literature is one of the fields. The other fields are crafts and folk arts, media arts, film, design, gastronomy, music. Do like, share and subscribe our channel. Thank you for watching.